name's Brien. I'm joined today by my colleague from Chambers, Richardson.
Hello.
Thank you for tuning in to the second in this series of webinars covering issues in the First-Tier Property Chamber. And today we are going to be discussing issues surrounding HMOs, particularly what buildings and properties are covered by HMOs, the issues surrounding licensing, and straying slightly outside the FTT, talking about what offences can be committed in respect of HMOs. Alice is going to kick us off by the basics by explaining to everyone what actually is an HMO.
First, a standard test. There's a couple of slides here which have set out the different criteria. First criteria is it must be one or more units of accommodation that are not self-contained. Then the living accommodation must be occupied by people who do not form a single household. And I'll come on in a second to what a single household is. Then the property must be occupied by those people as their only or main residence. And their occupation must constitute the sole use of that accommodation. Lastly, rent has to be payable or some other form of consideration by at least one of the occupants. And two or more of the households must share one or more basic amenities, or it must be lacking in one or more basic amenities. So this test really applies to the most common type of HMO, essentially a shared house, purpose-built bedsit accommodation. It might also apply to a hostel. As I said, I'll set out what a single household is, and that's in section 2582 of the Act. Essentially, members of the same family form one household, as would domestic employees such as an au pair or a nanny, and a living carer as well. Next test is the self-contained flat test. This is a self-contained flat that meets the requirements of the standard test. So it's a flat rather than a building, but meets all the same requirements I've just set out. And then the converted building test. This is obviously a converted building with one or more units of accommodation that are not self-contained flats, and the accommodation is occupied by people who do not form a single household. This, I think, most commonly would apply to a house that's been converted into a bedsit, for example. People must occupy the property as their only or main residence. The occupation constitutes the sole use of the accommodation, and rent is payable by at least one occupant. Other types of HMOs, under section 257, where a building or part of a building has been converted into and consists of self-contained flats, it will be an HMO if certain requirements aren't met. And then under section 255, a local authority can make a declaration that a house is in multiple occupation, where it's satisfied that the premises meets one of the three tests that I took you through earlier, and the occupation of the living accommodation constitutes a significant use rather than a sole use of the property. So if you get a declaration under section 255, it makes it clear that the local authority regard that building as an HMO for the purpose of the Act. An example of that might be a hotel that takes short-term guests, but also provides long-term accommodation for homeless people. In order to make that declaration, a local authority must serve a notice that the building's been declared an HMO on the relevant people within 7 days of making the decision, and that notice will come into force after 28 days. And there's a period within that 28 days during which the person on whom the notice is served can apply to the FTT, basically to appeal the notice. If they do so, the notice only comes into effect once the tribunal has made its decision and the time for appealing to the upper tribunal has elapsed.
Fairly straightforward issues then as to what buildings and properties constitute an HMO. Before we get on to talking about the licensing issues, it's worth flagging up Schedule 14 under the Act. It sets out a number of exemptions as to what buildings which would ordinarily meet the criteria are not actually an HMO. They're there for everyone to see, but as an example, it includes where a landlord is a public sector body, university halls, certain religious communities, and owner-occupiers or buildings with only two persons in them. Alice, it's over to you to talk about licensing issues and particularly when HMOs do and do not require a licence?
So the question of whether a property is an HMO is a separate question from whether or not it's required to be licensed. We're talking here really about the mandatory licensing regime, but as I've set out on the third bullet point on the screen there, it's important not to forget about the additional licensing schemes. There's also the selective licensing schemes, and it's important not to forget about those. What we're going to go on to talk about, the powers in relation to mandatory licensing and the various offences and defences. The similar powers also apply to additional and selective licensing regimes. The licensing of houses in multiple occupation prescribed description England Order 2018 contains the description of a mandatory HMO, and that is set out on this slide. So if there are 5 or more people forming 2 or more households and the property meets either the standard test, the self-contained flat test, or the converted building test. And I've put in bold at the bottom there, it does not have to be 3 stories. A previous version of these regulations said that a property only required a mandatory licence if it was over 3 stories. The current order does not require a property to be over 3 stories. So if it meets those 3 criteria, then it falls within the mandatory licensing regime and must be licensed.
Hopefully that sets out in fairly clear terms when buildings are an HMO, and second to that, when they do require a licence. In terms of the formalities of applying for a licence, again, there's nothing too controversial here. It is, of course, the local authority that deals with it. The applications must be made to the local housing authority as per section 63. And it may seem obvious, but the authority has either 2 options. They can either grant the licence in accordance with subsection 2, or alternatively refuse to grant it. They simply cannot sit in the fence, as we will see shortly. But before refusing a licence, the local housing authority must serve a notice and consider any representations made. And if they do go on to ultimately refuse the licence, they are required under the Act to serve another notice and give reasons for that refusal. In terms of where the applicant can go from there, they do have a right of appeal to the First-Tier Tribunal under the Act, failing that to the Upper Tribunal, and then, of course, the Court of Appeal if needs be. Alice, you were actually involved in a case concerning the local authority dealing with a licence application, specifically their failure to respond, and that case was Mirza. Can you explain very briefly what happened in Mirza?
Yes, Mr. Mirza was my client. He owned a large block of accommodation, was required to be licensed. He made an application for a licence for the block. The local authority did not process the application, responded and said the application was invalid on the basis that the property was separated inside into 4 separate blocks, and there was 4 separate entrances into the different quarters of the block. So the local authority considered that each individual quarter constituted an HMO in and of itself, and he was required to apply for 4 licenses, 1 for each block. They then prosecuted him, and I appeared on his behalf in an appeal to the Crown Court. And I argued that it was an abusive process because he had made an application for the block as a whole, and they hadn't dealt with it in the way you just set out. They hadn't given him the opportunity. They haven't refused it formally and then given him the opportunity to set out why it shouldn't be refused, and they hadn't given him the opportunity to go to the tribunal. I've quoted there from the judge at the bottom in his judgment where he said it effectively amounted to a Mexican standoff between the parties, with my client saying it was 1 block and the local authority saying it was 4. But ultimately, them proceeding straight to a prosecution, having not properly dealt with his application, resulted in an abuse process argument being successful and the prosecution being thrown out.
In terms of conditions of a licence, and this is an area where we'll perhaps see more cases in future. First off, there's a list of mandatory conditions that the local authority must include in their licences. Again, they're set out in Schedule 4. They're there for everyone to see. There's nothing too controversial about them, and they include most issues in relation to safety, including a gas safety certificate requirement, electrical appliances, safe, smoke alarms, etc. And there's also some new provisions in relation to the size of a property, certainly the size of sleeping arrangements in a property, subject to how many people are in a sleeping room and the ages of those people. But perhaps the more litigious aspect of conditions is the discretionary conditions that can be set out under Section 67. And the local authority has the power to consider or to grant any conditions attached to the licence that they consider appropriate for regulating either the management, use and occupation of the house concerned and or its condition and contents. And that's slightly more widespread than the power under Part 3. And one recent example of this was a case concerning the restriction on student lets in Nottingham. And the Supreme Court agreed there that that was a suitable use of a condition in terms of the number of students in certain houses. That deals briefly with the various conditions that can be attached to a licence, but without going into too much depth, we'll now look at the offences that can be committed in terms of licensing and failure to abide or adhere to the requirements. Alice, do you want to take us through that?
So the various offences under Section 72, the first one is having control of or managing an HMO, which is required to be licensed but is not so licensed. Recent case in Mohammed and London Borough of Waltham Forest clarified that this is a strict liability offence. The prosecuting authority do not have to prove mens rea on the part of the defendant. Then under Section 72(2), it's an offence to knowingly permit people to occupy in numbers greater than that permitted by the licence. Under Section 72(3), it's an offence to fail to comply with the licence conditions. And the maximum penalty for these offences on summary conviction is now an unlimited fine. Set out here, Section 251, where an offence is committed by a company with the consent, connivance or neglect of, for example, a director, manager or secretary of the company, that person also commits the offence. And Morgan, we were both involved in a case where the local authority prosecuted both the company in the company's name and the sole director of the company himself. And in that case, the company, I think I'm right in thinking, in that case, the company had pleaded guilty, but the director did not. And for the local authority, they had to prove that the offence was committed with his consent, connivance or neglect. And essentially they were able to prove that ultimately on the basis that he as a director had not ensured that there were sufficient processes in place within his company, that he knew when the property had to be licensed, how it had to be licensed and what had to be done. Do you think that's fair?
Yes, I think that's probably a fair reflection on the case, and the judge ultimately relied on the neglect part of the section in terms of his finding. And I suspect this will not be the last case that appears before the court where the sole issue is whether a director is guilty as well as the company, because simply by being a director and the house in question is owned by the company, it does not absolve the director of liability. That said, the prosecution or the local authority cannot simply rely on the guilt of the company as evidence of the director's guilt. They have to show something more, as Alice has helpfully set out. Yeah, so that deals with the offences that can be committed under the Act. I'll look quickly at what offences are available. There's two main defences that are set out in the statute as per Section 72(4) and 5. The first one relates to a notice being served by the property owner in terms of either seeking to remove the property as an HMO and showing the steps that they are intending to take to do so. And secondly, a defence under Section 72(4) that they are they have applied for a licence but are waiting the outcome. The more litigious defence is likely to be that provided by section 72(5)(a), which is a defence to any of the possible offences that a reasonable excuse to the offence being committed. One example that was given, case of IR Management Services and Salford, confirmed that in relying on the defence of reasonable excuse, the burden of proof is on the defendant to establish that it's not for the prosecutor to establish anything. And another case, not that long ago, Thanet District Council and Grant, although it was not decided by the court in appeal, it did consider that a property licensed through a respectable letting agent to a respectable tenant with references, who then created the HMO outside the landlord's knowledge, may amount to a defence of reasonable excuse. As a result of the Mohammed case that Alice was talking about earlier, this issue is likely to be raised more frequently, as that is effectively now the only avenue for property owners to argue that they are no longer guilty of an offence, due to the fact that there's no mens rea attached. Alice, you're going to deal with the other possible offences and enforcement mechanisms that can be taken under the Act.
Well, all I really wanted to say about the other offences is just to be aware that in addition to those we've set out, and we don't have time to go into them, but there are various other offences in relation to the management of HMOs, primarily set out in the two regulations on the screen there. And again, the maximum penalty for those offences is an unlimited fine. And then lastly, we just wanted to touch on the various routes to enforcement that apply in relation to breaches of HMO legislation. So obviously prosecution under section 72 that we've talked about, rent repayment orders in the First-Tier Tribunal, that might be something we'll cover in a future webinar if there's sufficient demand for it. It's something that I'm seeing a lot more litigation in. Then the fit and proper person test, obviously if you've got a conviction in relation to any of the offences discussed, that's going to affect your ability to satisfy a fit and proper person test in future. Then civil penalties under section 249A, that's an alternative to prosecution that the local authority have open to them, and we are definitely doing a webinar in this series looking at civil penalties. Then banning orders under the 2016 Act, and of course you can't serve a section 21 notice if a property is required to be licensed but is not licensed under section 75. That's everything that we wanted to cover in this talk. It's been a bit of a whistle-stop tour of HMOs and the various regimes. If anyone has any questions, they can get in touch with us or anyone in the housing team at Trinity. And coming up next in this series, Morgan and our colleague James McHugh are going to be talking about improvement notices under the 2004 Act. Thanks for watching, and yeah, get in touch if you've got any questions.